correct.
Justice Kagan? Justice Gorsuch?
I got a question from a totally different direction, Mr. Larson. So everybody's litigated on the premise that Congress can double punish for greater and lesser included offenses if it speaks clearly, but it must speak clearly. Where does that presumption come from?
It comes from a couple of places. Your Honors talked about this in the Whalen decision. Number one, separation of powers. Courts don't write laws punishing criminal conduct. They don't set the penalties. Congress does that. That function by the Constitution is committed to Congress. So courts are very
Well, we normally
careful.
interpret statutes without a thumb on the scale. You ask us, everybody asks us to put a thumb on the scale. Where does that thumb come from?
Yes, the presumption, right, because we're afraid of violating the separation of powers, and we're also afraid.
Is that lenity? Are you just afraid to utter the word?
I'm a great fan of lenity. And I believe Your Honor is too. Maybe not everyone in the room is a fan of lenity, but I am. But putting lenity to the side.
It has to come from somewhere.
Yes, it comes from the historical practice that historically speaking, legislatures don't double punish one crime, right? And also, constitutionally, it's the legislature that decides on the punishment, not a court. So a court, before it veers out of its lane and says, you have to double punish this person, there better be something very clear from Congress indicating that that's allowed. Because as the court said in Whalen, if we get this wrong, we violate not only the separation of powers principle, but we also trench especially harshly on the individual freedom aspects that are protected by the Double Jeopardy Clause.
And this court has sometimes said the presumption, but in other cases it said there is no double jeopardy prohibits two punishments for one offense, and that includes greater and lesser. I'm thinking of Pierce, I'm thinking of Shiro. How do we reconcile, like Hunter on the one hand and those cases on the other?
Well, Hunter was just Missouri's version of 924C. You know, if you commit a crime with a gun, you get a punishment for the gun in addition to the punishment for the underlying crime. Nothing in Hunter speaks to the situation here.
Well, I'm wondering, Hunter was issued during the Grady era when we treated Blockberger as a tool of statutory interpretation, and therefore kind of a presumption, if you will. But Dixon overruled Grady, right? And so I wonder, you know, is Hunter still good law, or is it Shiro and Pierce? And let me add on to that. You know, the possibility of punishment, dual punishments for greater and lesser included offenses really wasn't possible for much of our history because you didn't have joinder of criminal offenses. And so necessarily, once you try one, you're done. You know, you try the greater and you're done. And there is no opportunity for double punishment. So I'm just wondering what you make of all of that.
Well, historically speaking also, Your Honor, most felonies resulted in losing your life. Yes. So this question wasn't, you know, as present as it is nowadays. But the court has consistently adhered to the Blockberger rule for over 100 years. Even in Blockberger, it cited a case from 1911, citing a Massachusetts case from the 19th century. The court has had many opportunities, it's observed, in Rutledge and other cases, to abandon this rule, and it hasn't. And if it's just a presumption, we acknowledge that. The presumption can be overcome, but that's what's missing here, Your Honor.
I'm wondering, why can the presumption be overcome?
Because the court has decided that despite the
double jeopardy clause say
that's
you can't
precisely
be
right.
punished twice for one offense. We have one offense here.
And that's the funny thing that I also, you know, discovered in this case, Your Honor. Despite those plain words of the Double Jeopardy Clause, the court has consistently understood that to be a check on courts and not on the legislature, because punishments
Thank you, Mr. Larson.
can be whatever a Congress says they are.
Justice Kavanaugh?
Well, the Second Circuit here, I mean,